You are listening to the Bell Post. We are here today for one more episode of the Bell Post. And today we have a guest all the way across the country from North Carolina, and her name is Julie Henderson, and she's the president of the North Carolina Bell Agents Association. Did I say that correctly?
You did, yes, sir.
Oh, thank God. Well, welcome to our podcast, and thank you for agreeing to come on and talk to us about Iryna's law that was passed by the North Carolina legislature recently.
Well, thank you for having me. I appreciate the opportunity to talk on behalf of North Carolina.
Well, we said before we got started that I always like to find out as much information as I can about someone before they appear on a podcast, because I've been on podcasts before where they just say, "Hey, introduce yourself," and I always think, no, I want to stop that from happening. I want to find out as much information as I could, but I really couldn't find out that much information about you. You're the president of the North Carolina Bell Agents Association,
Correct.
but that's really, I mean, and like you said, everybody in North Carolina already knows you. And that's one of the things I sell or I say about bonds, the Bell industry. It is a personal relationship industry. And
It is.
so our relationship with the defendants, our relationship with the courts, our relationship with judges, with the police, our relationships with the legislature. Talk about that for a moment. Why does everybody in North Carolina, as you said, know you?
Well, I've been around for 23 years in
Just
the
a
state.
short time, just a short time.
Right, just a minute. 23 years in bail. I've actually had bonding experience. I'm a bail bondsman now, obviously. I have surety company experience because I was a regional manager for one that, is no longer around. They sold out a couple of years ago. I do know lots of folks in North Carolina because of my volunteering and participating in the state association for so many years. And then obviously I know several folks nationally as well. I had never had the opportunity to meet you prior to this, but I did know about your podcast. So, yeah, that's how I know a couple of folks around here. But my focus is mainly home life and bail usually wins most of my time every day, as most bail agents that I know.
Well, when you say home life, what does that mean to you?
So I do have a wonderful husband. We call him the first gentleman now since I got president. I have a 17-year-old son. I have two stepsons. So, home life, friends, family, local here. But I get drug away quite a bit due to the association work, which I'm happy to do.
Well, you have a son. I had two daughters that I raised or I helped raise or I was kind of involved in a little bit. But to me, I mean, being the father of girls is completely different than being the father of a 17-year-old boy, but boys. So talk about that. What's it like to be the mother of a boy?
Uh, I think that there is a reason that there's so many memes and jokes about being a mom to a boy. They're, I think, easier than girls in a lot of respects, but also I think they're much more difficult. Men, in my experience, don't tend to be forthcoming with information or what's going on with them. So having a teenager and getting out of them anything beyond a yes or a no response to a question is sometimes incredibly difficult, but I'm very blessed with a very good son. So,
Well, I have a daughter who's 26 and is engaged. So we're in the middle of planning a
oh,
wedding. We just picked out, or she picked out a wedding dress last Saturday. But I don't know if I've ever told this story, but sometimes I think I'm smarter than I really am. So when she was a lot younger, she got in trouble, and I was going to prove how smart I was, part-time psychologist and all that. So I gave her a choice between we were going to take away her, you know, Walkman, I guess would be the equivalent of what it was then, or we're going to take away her little digital device for a week, or she could get a spanking because she was not going to take spanking. Well, she took spanking. Well, then now you're cornered and you've got to give her a spanking, and then and so we went upstairs. I gave her a spanking. She started crying. I started crying. And she looked at me and said, "Well, why are you crying? You're the one that gave the spanking." And I'm like, "Dads do not like to give spankings." And
I
so
would
about
agree with that.
and so
I would
about an
agree.
hour later, she came up to me and she gave me her little device and said, "Hey, I've changed my mind." And
Oh,
I was like crying all over again. There's no take backs on spankings. And I mean, that scarred me. I mean, we always think of, when you do something like that, it scars the kids, but that scarred me and I'll never forget that. And it's a memory that I will always have in my head for how dumb I was.
it's so hard to raise kids. There's no rule book, there's no
Mhm,
guidebook, there's no instruction manual. So
mhm.
I kind of feel like if you're worried about the decisions that you're making as a parent, then you're doing it the right way because you're worried
Mhm.
about it.
I
Um,
think that's a good advice. I mean, really good advice. I mean, we had trouble getting pregnant with our second child, so there's a 6 year age difference. And then she was born with issues, and so she had to have a bone marrow transplant when she was 5. And so,
Goodness.
and I do say that there are things from that time period that we still cannot talk about. But we did it because she didn't make enough platelets. Her platelets today are normal. So she's a
Right.
junior in college. And so we're very, very, very blessed. We would
Yeah.
say even during that time period, we were very blessed. I mean, we spent Christmas in 2000 and no, 2010. We spent Christmas at Children's Hospital in Dallas, and we remember that as a really wonderful experience. So,
Right.
but we were very, very close as a family as a result of it. And, we need to move on. But when I worry at night, when I wake up at night saying, have I screwed up as a parent? I think about that. And I think about my oldest daughter and say,
Right.
did we protect her enough? Or is she scarred because of the amount of time that we had to spend with our youngest child? But I agree with
Right.
you. If you worry about it, then you were at least trying to do the right thing.
Right. You're trying to do the right thing. You're doing the best you can with the information that you have. Right.
Yeah, that's right. And you know what? I like to say that to her because she now works in the bail industry for my biggest client, and so in a lot of situations she's my boss now, and so I
I
like to
love that.
say, yeah, yeah. So I stand up before an administrative agency and say, "This is my daughter. This is my boss." So we're
I
very
love it.
close, and she has my sense of humor for good or bad. And so it'll be interesting when she gets married in June because she was asking me who's going to be the pastor. And I'm like, "Ah, I'll do it. I'll be the father of the bride and the pastor." She said no. So, we've laughed and we're here to talk about a very serious subject. And it's,
Yeah.
the whole background of Iryna Zarutsha and the situation where she was killed, murdered on was I guess the subway. But I mean, how did you first hear about this? Like everybody else from the news?
It was the news that I first heard about it, to be honest with you. Charlotte, North Carolina is unfortunately known for crime and horrible crimes. It's very liberal, and I don't care, what side of the coin you're on as far as your political preference, but that is just a known fact. There's it's just well known. Law enforcement, citizens. I mean, you live in North Carolina, you know that Charlotte is just one of those areas. If you go there, you need to be careful. If you go there, you need to be aware of your surroundings. Like it's just known for the crime that is there.
Well, okay, so let's back up. We've been through this period of bail reform, criminal justice reform, and there was, I would say, a period of 5 years where these reforms were really kind of stuck down our throat, and we were gagging them. We were saying they didn't weren't going to work. But how did that movement affect what was going on in Charlotte?
I don't think it, as far as starting that movement, I think that just went along with what Charlotte has always wanted to do.
Hmm,
Okay.
hmm.
They've always wanted to be, hey, don't do that again. Try again next time. The soft on crime stance. So that just played right along into what Charlotte has already done. I mean, we literally call it the great state of Mecklenburg for a reason. Because they make their own rules and there is no rule book that they necessarily have to play by, but their own. So, you
Well,
mentioned,
when you mentioned soft on crime policies, I mean, that
sure,
really hits me pretty hard because we've been through a period where had these, uh, you know, overly forgiveness where we look the other way and we look the other way I mean, for career criminals. We just don't want to put any
Yes,
more people in jail, even though they've shown that they have an intention to commit more crime.
correct, correct. And so it's pretty sad when we're to the point to where the people that are committing the crimes have more rights than the victims.
Hmm.
And it's been going so far left for so long with the stance on crime, not just in North Carolina, but nationwide.
Hmm.
Now we see the trend of kind of swinging back to the right. I don't want to see us go too far right either.
Yeah.
Someone that is panhandling shouldn't be locked up for a year in county or a prison. They shouldn't. But there is a happy medium there, and we know that.
Yeah.
As a bail agent, I know that. I've seen it work successfully my entire career. But you have to have common sense. And I think that is so hard to define and put someone into place that understands that common sense needs to be applied.
Well, when I agree with the pendulum, when the pendulum swings to the left, and I would say during this bail reform, criminal justice reform movement, it has really swung pretty hard to the left on this soft on crime policy.
Yes,
And I agree with you. I think it's stopped and it's swinging back to the right. And but the point I would make is the public doesn't support when the pendulum goes all the way to the left, where we decriminalize all these crimes and crime starts going up and commercial property values start dropping. But at the same time, I agree with what you just said is the public's not going to support the pendulum when it swings too far to the right, which really ends up in more preventative detention. The public's not going to stand up for more crime. They're not going to pay for holding
correct.
everybody pretrial in jail. Like if we use the federal model, 75% of people are held pretrial. And so, when you say we're the middle ground, I think that's true. The bondsmen are the middle ground. And the way you protect it is by having a strong accountability laid on top of it. Give people a chance. If they break that, then they don't get 15 more chances. They may get one more chance. But I think what you said is so important. We're the happy medium at no cost to the taxpayers. And, we have the best get them to court record of any of the release mechanisms. And that's what everybody fails to see. When you use us, everybody goes to court.
That's correct. Over and over and over again, we know that. We also know that in North Carolina, specifically, probably other areas of the country, we've been hearing it's going to take somebody getting hurt or
Yeah.
killed for the public to know or to
Mhm.
recognize what's going on in the criminal justice system. And unfortunately, that's exactly what happened in this instance. And it's just so sad. This beautiful girl should not have lost her life in the manner that she did. She shouldn't have lost it at all, but especially in the manner that she did.
Yeah.
Um, you know, the gentleman, and I use that terminology loosely, that committed this crime, he's got a history. He has a long history. And there has been lots of talks about, oh, he was arrested in January of 2025. The magistrate actually said, not a bond at all. She let him sign a written promise to appear, just a promise to come back to court. Well, I do want to say very clearly, lots of folks are pointing at magistrates in North Carolina. We need to look a little further than that. Okay. First of all, she said a written promise to appear. I'm not a magistrate, but I wouldn't have done that because he's listed as homeless,
Yeah.
on his release order and the documents. So there's no accountability for him to come back. But he was charged with misuse of 911. That is a misdemeanor. If he had been found guilty of that, he would have only served 120 days. Okay. He would have already been out by the time this murder was committed. I think people are not recognizing that fact. But his history prior to that, which was much more serious, is where he should have been caught up and behind bars. That's sort of where I want folks to look.
Okay. So let's focus on that when we get to talking
Mhm.
about this gentleman. But before we do that, I want to highlight some things that I learned about Iryna Zarutsha. Is that right? Yeah, Zarutsha. She was 23 years old at the time she died. I mean, 23 years ago is a long time ago for me. I mean, I've pretty much tripled that almost. I mean, I'm 64. So I was trying to think, what was I doing when I was 23 years old? I was probably still trying to figure things out. I mean, at 23, I mean, I don't even know. I mean, so I was probably, yeah, I hadn't even gone to law school yet. I was 26 when I went to law school. So I was
Right.
29 when I graduated. I went to um, Vegas when I was after I passed the bar exam and to celebrate, and they tried to kick me out of the gambling floor because they thought I was too young. They was younger than 18, and I'm like, I'm 29.
Right.
So at 23, I mean, I'm just like, wow. She'd already studied at the Synergy College in Kiev, and she'd earned a diploma at the age of 18. Her family lived in Kiev following well, they lived in a part of Kiev and they were part of the Battle of Kiev. Their neighborhood was bombed after the Russian invasion of 2022. They lived in a bomb shelter for a period of a month. And then her mother and her sister and her younger brother immigrated to the United States in August of 2022, living with an aunt and uncle in Hunterville, North Carolina. Their father remained in Ukraine because he couldn't leave the country because men between 18 and 60 were precluded from leaving the country because of the war. So she came with everybody but her dad, and then in Hunter and stayed with a relative. They came to the United States the right way. They had a
Correct.
sponsor. And so in Huntersville, she has, we find out she has a boyfriend. Sounds like he's also from Ukraine because I mean I
Yes.
saw him talking on the news. Um, Her boyfriend gave her driving lessons since her family had never owned a car. She eventually moved to Charlotte with her boyfriend. She enrolled in college. She started working at a pizzeria in the lower South End. And on the night she was attacked, she had finished working at the pizzeria and she was just going home on the Lennox Blue Line when this incident happened.
Correct.
I mean, we've talked about kids, raising kids. I mean, she did everything the right way. I mean, this is what you would want. I mean, I don't know if I want my daughter who's 23 living with some guy, but other than that, I mean, she looks like she's got it all together.
Correct.
And I think the reason why this went global is because of the video. I mean, and the
For
video
sure.
shows she's just minding her own business. She's not harassing anybody. She's not even acknowledging anybody. She's really just looking on her phone like hundreds of other 23-year-olds or thousands of other 23-year-olds. You're just going from point A to point B. And she's like my daughter. She has her location services, Find My Friends on. I can track her. My wife is a much better bloodhound tracking on Find My Friends, but that's how her family knew something was wrong. They were looking at her
Correct.
phone and she didn't move. Her location stayed the same. Tell us, I mean, is there anything about the way this was portrayed in your area that, is different than what we're hearing in the national news?
Um, I don't believe so. I know that obviously the video, it took me a couple of tries, honestly, just to watch it,
Hmm.
um, just to get through it because you knew what was happening. I will say for people in my area, we are from the South, we're rural area where I'm at, and most everyone that I talked about the situation with was not only just devastated by the actual murder, but also the inactivity or the people who were sitting there who did nothing to help or stop. That would never happen in my area. I assume that some parts of Texas are the same.
Well, but
Um,
it happened so
oh,
quickly because,
it did.
if you watch the whole thing, several people did go to her after
Right
he
after.
walked away.
Right.
And he moved so quickly. I mean, it
Yeah.
looked like he tried to stab her a couple of times in the neck, but only, the autopsy said only she had one puncture wound, either hit the same place twice or he only, I mean, I know the video was hard to watch. And
It
it's
was.
really hard when he walks away and says, I got that white girl.
Yeah.
I mean, you know that it's for no other reason. It wasn't because of who she was, it was
Right.
what she was.
Right.
And it was hard. When you first watch it, you're like everybody's looking at him like, am I next? What do I do? And they were all seems like everybody was concerned about and you act and it and the other thing is it just happened so quickly. I mean, you wouldn't
It
even
did.
know that she got hurt, really.
Ooh, I don't I don't know. I wasn't there. I just know from the video and from what we, it is. We're very small town, we're very rural, and it's
Hmm.
just immediately, little old lady trying to cross the street, people are going to stop and help. And it was just absolutely heartbreaking, for all of us, I think.
Well, I used to teach Sunday school, and I don't think I've ever talked about this for seniors, high school seniors.
Sure.
And there was a lesson one time that we talked about something like this. You are you by yourself and you walk up and there's a group of people who are either harassing someone or they're taking advantage. What do you do?
Right.
And, we all want to say, I mean, it's like when in law school, you take this class of ethics. And, in law school, every time they give you an ethical situation that you don't like, you say, well, I would just withdraw. And it just made me so mad because I'm like, withdrawing is never the answer. Let's just add to it. You're married, you've got 3 kids, and you're trying to pay for
Right.
college.
Right.
So withdrawing is never the option. What do you do? Because that's the default. Same here. I was like, and the point I was trying to make is, what do you do when there's no wrong decision? There's
Right.
no wrong answer. What do you do? And are you going to make a decision that you can live with as a Christian?
Sure.
Or are you going to make a decision that may put you in at risk of being hurt?
Right.
And I had one young man in my class, and he was scrawny little kid, and he's like, I would get in there and I'd try to stop him, and I'm like, you're just a scrawny kid. And I said, yeah, and I just keep throwing myself at him, and so I really remember that, and that's been probably
Yeah.
10 or 20 years ago, and so I like the sentiment. I don't know if I mean, I wonder what I would do in those situations.
Right. Well, I hope neither you nor I ever have to find out,
Yes,
obviously,
that's
as
right.
what I hope. Um, but it is. I would just say that was the context of the conversation from those, in my immediate circle and what we had seen, of the video and of the news stories. I do think that the majority of what we were seeing and hearing is the same as you guys were probably seeing and hearing.
Well, let's talk about, the gentleman, and I'm just going to call him Mr. Brown. I'm probably not refer to him by name again, but this was someone who was 34 years old. He had been arrested 14 different times, and he had criminal charges dating back to 2007. On April 11th, 2014, he was convicted of breaking and entering, and then while on probation, he was arrested for armed robbery and possession of a firearm by a felon. He was convicted of armed robbery and incarcerated in state prison from 2015 to 2020. Upon release, he initially lived with his family, but his mother told the news that he was diagnosed with schizophrenia at this point and displayed violent behavior at home. I think he eventually quit taking his medications. She couldn't control him. I think she even came out on the news saying he should not have been out. He should have been in jail. Um, The Associated Press reported that involuntary commitments are difficult to obtain unless a court finds the person to be dangerous. North Carolina reduced the capacity of state hospitals in early 2000s, and the average wait time for a psychiatric bed was 16 days in 2024. After Brown stopped taking his psychiatric medication, his mother took him to a homeless shelter. So if you're not going to take your meds, can't be in the house. And so he still decided that he wasn't going to do that. I mean, if he's not listening to his mom, is he going to listen to anybody?
Right.
Uh, in January 2025, he repeatedly called 911. So he was charged with harassing 911, like you mentioned. And he was charged with the misuse of 911 and released without bond, like you mentioned. Um, I agree with you on that point that I'm not, I don't think we can say the magistrate made a, a wrong decision at the time they magistrating for misuse of the 911. And I understand your point about there was lots of other opportunities that he came into the criminal justice system where he was not handled properly. I mean,
Right.
One of the points I like to make, or I do make, I don't know if I like to make it, is that this criminal reform, criminal justice reform movement, we've kind of taken mental health and we've just made it a King's X sometimes on the criminal case. And so we dismiss it and just put them right back out on the street instead of trying to address their issues.
Correct. Absolutely.
And the problem is I don't know what the solution for that is because for a long, long time we've put them in jail and the jails have become the largest mental health facilities in the country. And as a result, we've reduced the capacity of all of our mental health beds that we otherwise would have had. But those have all been on the decline anyway for years because they were not handled correctly. Whenever the county needed a budget cut, that went first because they have no constituency behind them really. And so I keep telling people if we could find a solution to the mental health problem, we could become billionaires because there's not an easy solution here.
I would say 1,000% yes. When this bill started, making its rounds, there were several people that were speaking to legislators about it, the pros and the cons, and over, I know that the North Carolina Bail Agents Association, Tom Apodaca, who's a lobbyist for the American Bail Coalition, he told legislators very clearly, this is above my pay grade, but what you need to do is you need to open up Broughton Hospital, and there's another one down east in North Carolina, and you need to open them up to full capacity because that's one of the biggest issues that the state of North Carolina has, along with other
Hmm.
states. They need the help. They shouldn't be on the street, and
Yes.
everyone knows that. And so they get put in jail over and over again where they shouldn't be either.
Well, I
They
think that's a
do,
good point because let's do a comparison. When they go to jail, they get put on their meds, they start taking their meds, they're controllable, they get released, they get off their meds, they get uncontrollable, and they get
right,
arrested. And it's a revolving door.
it
If we
is
open up the facility and we put them in there, they are going to take their meds because the meds are
right,
being regulated by staff. I mean,
correct,
another example of that is I have a sister who's 11 months younger than me, and she had a car wreck in '89, right after I passed the bar exam, right before I found out. And she started a 30-year drug addiction to
oh
prescription
goodness,
painkillers. And it was only at the end of her life when I declared incompetent because she also had a brain injury. And we got
right,
her into an assisted living facility where they managed her medications. That
right,
probably she went into probably the best time of her, life since she'd been on all these drugs because she
right,
could no longer abuse them. She could only get them. I mean, it was tough for a while because she would ask me as her guardian to approve her to get narcotics, and I would say no. And then
correct,
one time she pulled out all of her toenails. And so I had to go visit with her. Why are you pulling out all your toenails? Because I want narcotics. And I'm like, I'm not going to approve them.
right,
But I talked to the facility and I said, let's give Carla a job. She's got a brain injury, but she's still very smart with a brain injury. And so they put her on her hospitality committee. And suddenly she became the cruise director for the whole assisted living facility. And so for the last 4 years of her life, she was known as Carla with a smile on her face. And she would call herding her cats, her old ladies around. And so she became a different woman. And
it's because she was regulated and she had a purpose.
yes, and so I still say, even with if you are if you are run off by family for years, but at the end, if you still have an opportunity, someone with mental health issues, their best chance of success is with family than
It is,
without. And
it
so
is,
if we could get family involved, even if they're in a facility, they're going to have a much better chance of success than if we're depending on the state. And I know that's hard sometimes for families because I was estranged from my sister for years. And when I got back involved, and there's a long story there, um, but I had a chip on my shoulder about it for a long time. I didn't really want to even talk to her. I just felt like I was, pushed into it. But by the time she blossomed. I mean, it was like
right.
we were 15 and 16 again. We were able to talk every day.
Yeah,
And we didn't have that for very long because then she passed away. But I will not forget. I always like to say I've built up a lot of bad karma, in my life, that's a one example of some good karma that I've
Correct.
built up to offset some of the bad.
Right.
And we should all try to do that. And I encourage
Sure.
families with people with mental issues, keep trying.
Sure. 1,000,000%. I do think that that common sense approach that we talked about earlier still applies to this.
Mhm.
You have to have common sense to deal with someone who has mental health issues or has a drug addiction, right?
Mhm.
I'm all for people getting help. I'm all for people rehabilitating. I mean, I am a bondsman, for goodness sakes. I am in the business of second chances. And I believe in that 1,000%. I do know, however, on top of this, we have the issue of, again, like the rest of the nation, of sometimes career criminals know how to work the system. And
Yes.
so they will claim this or claim that to be released, and so that they can go into a treatment facility, or they can claim that they have an issue and then that they need assistance, and then that not be the case. That is also another revolving door that we have. And that is truly unfortunate as well.
Well, and that's a really, really good point about the King's X, by making the claim. And career criminals really learn how to play the system.
Sure.
And, the problem with criminal justice mental health support is they're in conflict because the
Correct.
mental health workers are taught we support the person, we believe the person. And so when they come in and say, we have a mental health problem, we believe it, we support it. And
Right.
so once you believe it, then if that's going to King's X the criminal case, then any career criminal is going to say, "Oh, I've got a mental problem, and you need to dismiss my criminal case." I've seen it, and I've asked mental health workers, "What's the fix for that?" And I was really kind of shocked when they're like, "Don't really know because we're trained to support what they say."
Correct. Every
And
time.
who's better to oh, what do you call it? Where they who's going to take advantage of the system better
Right.
than career criminals? And
Right.
I mean, you look at this guy, and he's clearly got problems, but he's also someone who's been in the system so long,
Correct.
so many times. I mean, the system failed this guy not just once, not twice, but many times. If
For
you're
certain.
measuring from, if you're measuring even from the perspective of the left, he wasn't given any treatment, not
No.
to address his issues. I mean, it was really just to get him out of the system,
Correct.
get him out, get him gone.
And and again, that just circles back around. It's happening here, it's happening in other parts of the nation. There's this revolving cycle, it appears, of let's push them through the court system, let's get them off the docket, let's clear the docket, and it doesn't matter what we do to clear that docket. We just want, our numbers to reflect we're doing our job, unfortunately. So it's going to take a little bit more of, I think, the public input on this to bring awareness to the situation. I hate that this had to happen. Um, I hate that it probably will happen again, before the public really takes hold of it and decides that something's got to change. Something has to change.
Yes. And so let's kind of continue. So the event that we've been talking about took place on August the 22nd, 2025. Um, so on that day, Brown spent several hours riding the Lennox Blue Line, during which surveillance footage showing him making unusual movements, laughing to himself, exhibiting things that would say he's got a mental problem. And, if I saw somebody acting like that, I'd give them a wide berth. At 8:18 p.m., he was passed by two Charlotte area transit system security officials, but did not interact with them. Local Charlotte television channel WBTV later quoted authorities as saying that Brown did not have a ticket to ride the train. I'm sure that's a recurring problem in that area. Homeless people are in the area because they get there without a ticket. All they got to do is climb over the thing to be there without a ticket. So at 9:46 p.m. that evening, Zarutsha boarded the Lennox Blue line at a specific station in Charlotte's South End neighborhood. from what you're saying, that has to be a, a area that is known for crime.
In Charlotte, yes, sir.
Yeah. Okay. Surveillance footage shows her sitting in front. So we've seen the video of Brown, who was already seated on the train. So all she did was just go look for an empty seat. And then 4 minutes after she boarded, he pulled a pocket knife from his hoodie and stabbed her 3 times from behind, including at least once in the neck. She remained conscious or semi conscious for nearly a minute. So she bled out within a minute. She collapsed on the floor. At least four other people were sitting near her during the stabbing, and passengers provided assistance after she collapsed on the floor. She became unresponsive shortly and then was pronounced dead at the scene. Brown is, and then we've already said Brown's reported what he said as he walked away, and it's on the video. Um, I mean, it's something that happened very, very quickly. I mean, it's like, I mean, I don't know. It's something that could happen to anybody. I mean, if she's riding the subway at 9:46 p.m., I mean, as a dad, I'm already worried about her just riding by herself. I
Sure.
mean, and you'd be like, well, let me meet you and I will ride with you home. But, not everybody can do that.
No, not everybody can do that. And I'm sure from their perspective, coming from where they originally, where she was born, where she grew up, and the environment that she came
Yeah.
from,
Yeah.
for goodness sakes, a war zone, I'm certain anything to them was more safe than that.
You're exactly right. They had to think she was safer on a subway in Charlotte, North Carolina than she was in the Ukraine in
Correct.
Kiev. Wow, that's a good point. And we've already talked about, there's been numerous elected officials who has asked for a proceeding to remove the magistrate from office. One of the things I want to talk to you about the magistrate is it seems like we've heard that you don't have to be an attorney to be a magistrate in
You do
North
not.
Carolina.
You do
What,
not.
what do you have to be? Just human?
No, I do know that, again, I'm in a different area. I'm about 2 hours from Charlotte, just for perspective in the mountains. But here, there are several magistrates that are attorneys, but there are also several that are not. Did they have some type of law enforcement or criminal background? Absolutely. I believe some have come from law enforcement specifically, some have come from probation, some have come
Sure,
from the
sure.
clerk's office. You also need to keep in mind that, hey, the General Assembly has got this, misconception that they should all be attorneys, where you're going to have to compensate them as such. Okay.
Yeah.
Because they're either going to go and be an attorney and make money, or they're going to be a magistrate, which I think the base salary in North Carolina is around $40,000.
We have the same issue that recurs with JPs. In Texas, a justice of the peace does not have to be an attorney, and they don't pay them like they're an attorney. And,
Right.
like it comes up in the legislature, well, we want them to be attorneys. Well, if you want them to be attorneys, you have to pay them because they're an attorney, and then it goes away.
You get what you pay for. Now, and I'm not saying that derogatory, because, again, I know a ton of magistrates who do a phenomenal job. I know magistrates that actually set bonds, because you got to remember, in North Carolina, the magistrate is hearing the officer's testimony. They're interacting with the defendant when they are arrested. So they're seeing what's happening with them, right? But they could set a bond, and then that defendant could go in front of a judge, and then that bond could be unsecured. They could be given credit time served for a few hours in jail on a felony drug charge. So the judge can override what the magistrate has set. Are there magistrates in the state of North Carolina who are not doing what they should according to the bail policy for their district or their county? I'm certain that there are. But again, I think that the finger is being pointed specifically at a magistrate, when in reality, we might need to take a look a little higher up the ladder.
Well, and I've talked to magistrates, I think even on our podcast where they haven't had where they're not attorneys, and I think they're great magistrates. So
Right,
I'm not going to say that you have to be an attorney to be a magistrate, because you have to be an attorney to be a judge. And
right.
a magistrate, a judge can be a magistrate, but a magistrate specifically in the situation we're talking about is someone who sets bail and does probably the initial appearance. That's all they do all day long.
Right.
And I think that our friends on the left have discovered that if they target those positions, they can have a huge impact on um, soft on crime policies very quickly.
I will say in the state of North Carolina, I believe soft on crime came down through the judicial side years ago versus the legislative side because they
Yeah.
couldn't get any traction legislatively. So they started targeting judges and that side to try to make that soft on crime policy happen.
Well, let's
That's
talk
exactly.
about the criminal proceedings that are pending, and just kind of before we move on and talk about Iryna's law, but there's both a state and a federal prosecution pending against this person, and my guess is because under the state crime they cannot get the death penalty. Is that right?
They could, but there's been so many, appeals and that sort of thing. And Arena's law actually touches on the death penalty,
Like,
actually, but because that's been so problematic for the state to carry through with, I do believe that's why, the federal charges have been pressed. I did see, I think, an article that Pam Bondi was going to ask for, the death penalty in this matter.
so for the state proceeding, a judge ordered a 60-day psychiatric evaluation at a local hospital on September 15th. He was indicted by a grand jury. He was charged in North Carolina state court with a first-degree murder. He's being held at the Mecklenburg County Detention Center without bond, and the investigation remains ongoing. On October 22nd, for the federal proceeding, he was indicted for committing an act causing death on a mass transportation system, and there's going to be a hearing held on April 2026 on whether he will face the death penalty as a result of that. I mean, I guess those are just pending cases. Is there anything that's in the news locally about the state or the federal case? They're just,
No, other than those items you just listed off, no, there
I
is
mean,
not.
September 16th, I mean, it's been pending for 45 days. And October 22nd, it's been pending for what, a week? I mean, today's the 30th. So, yeah, it's been pending for 8 days. So,
Gonna see if he's got a pending court date because that is actually available publicly now. Yep, nope. Administrative hearing scheduled for April 30th, 2026 in Mecklenburg County Courthouse. Yep, 4/30, 2026 for the state charge of the murder.
okay, say that again. So, there's a hearing.
On April 30th,
Mhm.
2026 at 9:30 a.m. in Mecklenburg County for the state charges of murder
Okay. And what
is
does that
what's
mean?
pending.
Just a status hearing?
It's just his next court date. It
Okay.
doesn't, let me see if it has any notes with that. Just says administrative hearing, so I'm not
Okay.
certain what that might be. There was a motion hearing other on October 3rd. Motion to amend medical records request was filed.
Okay. So, they're in the discovery phase.
In North Carolina, we are now all 100 counties are available publicly. So people can see a lot of the things that are actually happening now with court cases.
Well, before we get into Irena's law, I want to talk to you about one other issue that I thought, if, when the magistrate was magistrating him, I guess, magistrating, I noticed that one of the provisions of Irena's law is to require the review of criminal histories. Uh, so my question is the opposite. Before Irena's law, were the magistrates not required to review criminal histories before setting bail?
They should have been. I don't know the law right off the top of my head that states that, but I know that there is the necessity or the requirement for that because we also have something in North Carolina called the Pretrial Integrity Act. That means if you're already out on some form of pretrial release and you are arrested while that is pending, then you have to see a judge in order to have a bond set. The magistrate cannot do that. They wouldn't be able to determine that when they're taken in if they weren't looking at a history.
We know in Texas, until 4 years ago, I think 2 sessions ago, judges were not required to review criminal histories in Texas. They could, they had the
Mhm.
discretion to do it, but they were not required to. And then 4 years ago, as a part of SB 6, that was, I think, I would argue that's the major change because Texas didn't have the ability or didn't have a central database to review
Right.
criminal histories. So, as a part of the change, they had to set up a system to view and to look at criminal histories. And y'all did it a little bit differently, and we'll talk about that as we go through Iryna's law. And y'all may have done, you certainly did it cheaper. I promise you, you did it cheaper because the way y'all did it. And we'll talk about that. But so let's talk about Iryna's law because that's, I didn't really hear about it till it passed, but
Right.
it passed very quickly from the legislature. So it was filed, considered, and passed, and it was passed by a Republican legislature and signed by a Democrat governor, right?
It was. So that was quite unbelievable for a lot of us. We weren't certain, what the governor would do with it. We didn't know if he would veto it and it would have to go back to the General Assembly. We didn't know if he would just let it lie for the amount of days that it had to, like, not take a stance, but it would still become effective, or if he would actually sign. So
Well,
I
let's
think
talk
it was
about how the legislative session went. So, I mean, do y'all have a legislative session every year or every 2 years? What's the setup for North Carolina?
right. So we absolutely a long session one year and a short session the next. Okay. Short session is the year that most of them are running for office. They need to be out of the General Assembly so that they can campaign. This was actually long session this year.
Okay.
Um, but I will say that they had adjourned. They came back in just to hear this and a few other items before they adjourned for the year, if you will. Um, we found out about Iryna's law, I think, on Friday, and they had it on the Senate floor Monday morning.
Wow. See, in Texas, we have a session every 2 years, and it's only for a set number of days, and that's set in the Texas Constitution. So
Yeah.
after that, it's a special session. So, and a special session only lasts for 30 days. So what you're talking about for us would be the system that we think of for for a special session. You
Right.
have a special session called, immediately it's on the floor. I mean, it's in a committee that day, it's on the floor the next day. It's very quick process. So how did y'all respond to it? And what input, if any, did y'all have?
Well, they didn't listen to our input too awful much, I'll be honest with you. But of course, we were supportive in that, yes, this is a step in the right direction, especially with involuntary commitment and some of the other things we'll, I'm
Mhm.
sure, talk about. But as far as the purposes of bail, they did eliminate one of the five ways that you can be released, pretrial release in the state of North Carolina, one of them being the written promise to appear that we've spoke about.
Which
Now,
this gentleman received for the harassing of
correct.
911. So they got
They
rid of
do.
what he received for that.
Correct. Now, in my very humble opinion, after 23 years and lots of folks with a lot more tenure than I, they should have left written promise to appear. Even as a bondsman, I can see the need for that. You've got an 18-year-old kid, they stole a candy bar, they're brought in. Okay,
But it's got
you,
to have a high failure to appear rate. I
it
mean,
does. It does.
anytime you're just given their written promise, it's got to have at least a 50% failure to appear rate. So if I'm a judge, I'm very sparingly going to use that.
Correct, correct. Did we still see the need for magistrates and judges to use that if
Mhm.
necessary? We do. We know that there are those circumstances, okay? But what we said was you should have gotten rid of unsecured bonds.
Sure.
That is absolutely a form that is used and abused in the state of North Carolina. The general public hears bond and they think there is some type
Mhm.
of security or repercussion. There was none. With an unsecured bond, which is still being used in every county of the 100 in North Carolina, they are setting unsecured bonds every day. That is nothing more than a written promise to appear. If you want to use it, fine, but call it what it is.
Now, does it have a dollar amount tied to it? So it's really no. So what is the difference other than name only in a
It is the name. It is truly the name. Judges, district attorneys, magistrates, they do not want to be called on the carpet, in my, again, very humble opinion, for, doing a written promise to appear on this. But if they do a 50,000 unsecured bond, sounds great to the public. Sounds great to the
Mhm.
public. So they get that pass. And
Well,
the media doesn't do a very good job.
well, the press can't distinguish usually between
Correct.
a $50,000 unsecured bond and a $50,000 secure bond. They don't
Exactly.
realize that a $50,000 unsecured bond is still nothing more than a promise.
Exactly, exactly, exactly. So, at any rate, we definitely had phone conversations. We were the lobbyist, Jarrett Bird, does an amazing job. Thank you, Jarrett. And myself were actually there. Tom Apodaca, again, lobbyist for ABC. We worked very well together. He actually spoke at the Senate committee hearing that morning. He told them pretty much what I just did. One, good start, should have gotten rid of unsecured, kept written promise to appear. We talk all the time about the defendant's rights, but we never seem to talk about the victim's rights. So, that's paraphrasing his 1.5 minutes that he was allowed. And then, of course, it just got sent through that afternoon, evening very quickly by the Senate, went to the House the next day, and they debated it quite a while, but it did pass and then go to the governor. So,
The last time I testified at the Texas legislature, so I go every year working with lobbyists, but I'm the kind of one of the designated people to testify. And just like you said, you get 3 minutes and you have your little 3 minutes that you're playing. But, I was using all the data that we have because we have a lot of data now.
yeah,
And so I didn't just poke holes. I put a fire to the Democrats' talking points and
right.
they got so mad, they started asking me questions. 45 minutes later, they finally
Oh
gave
my
up
goodness.
because
Yeah.
I wouldn't back down. But
Well,
that's also the reason why we're always preaching to our members. You don't want to testify at the legislature if you don't have
right,
experience because you'll have
right.
your 3 minutes, they'll start asking you questions. And our experience is when they start asking someone who doesn't have the experience of testifying, they'll just start rolling over.
Correct. So 1,000% we're not done. This is a start. It did have the support, Arena's Law had the support of district attorneys. It had the support of the Sheriff's Association. Eddie Caldwell spoke on behalf of North Carolina Sheriff's Association, which is a very strong association, by the way, in the state of North Carolina. They said sort of the same. This is a good start. So our work is not done at all. We are
Well,
just
good.
starting.
That's
We are
great.
just starting.
So let's talk about what the start of these changes are. And this is Iryna's law and passed in honor of her. And it says in the statute it's to be referred to as Iryna's law. Uh, the first thing I want to highlight is we made a list of violent offenses. And I think the press has portrayed this as it's remove cashless bail for certain offenses. What's your interpretation or your play on that?
I think that we have a good start. I think that we have a long way to go. I do know that some violent offenses, were either listed by the classes, if you will. I think that
Yeah.
this goes a little bit further in specifying an actual act or the charge and not just the class. So hopefully that makes more sense to folks.
Well,
Um,
when I was preparing, I went through this and I went through this to the statute. So and second degree murder, first
right,
degree forcible rape, second degree forcible rape, statutory rape of a child. I mean, these are all clearly violent offenses.
correct.
Um, the Texas legislature did something similar 2 sessions ago, making a list of violent offenses, but they did what you're talking about. They said these violent offenses are not eligible for a personal bond, so they wouldn't be eligible for an unsecured
Right,
bond.
right,
And uh, I think that's been well received in Texas. I mean,
sure,
if you are charged with these offenses, you're not eligible for simple release, which would be
right.
like you've talked about, or the way in Texas, a release on a personal bond.
Yep, they definitely are pointing them directly to setting a secured bond or house arrest, which also has the addition of a secured bond. So
Oh, it
if the
does?
judge, it does, and it's number five of the
I saw that it
reason.
was number 5, but I didn't realize that if you get house arrest, you have to have a secure bond.
Yep, it's right there.
Ah,
So now what I do know that legislators are also getting twisted or misunderstanding is that they think ankle monitor means house arrest. No,
mm,
to be on house arrest, you're probably going to need that ankle monitor, but ankle monitoring as is not house arrest. That just
okay.
means you're being
Well,
monitored.
let's talk about that issue. So, I do not believe that ankle monitors can replace the job that we do.
They cannot.
Okay, well, why? I mean, the legislature is being told. I mean, they really are
Right,
being told we really don't do anything. We just get them out of jail and make all kinds of
right,
money. But I mean, the level of supervision that we give can never be replaced. But an
right.
ankle monitor sure can't do that. Why?
So I think that ankle monitors in conjunction with a
Hmm.
secured bond is the only way that they could be applied, okay? Because it's just a tool. It's just like if I'm going to have them call and check in with me, because that ankle monitor, depending on who is monitoring that,
Hmm.
could be great or it could be horrible. So if you have an entity or a company that is not monitoring those on their ankle monitors, then what's the use of having it?
Well, we
The
have
statute,
examples in Texas where somebody's, the monitoring service didn't work on weekends.
right,
And so they
right.
can do whatever they want on the weekend. You think they don't figure that out really quick?
Correct. Correct. And so I tell people a lot, bail agents in North Carolina, I know a ton of them that do ankle monitors as well.
Hmm.
And so, as a tool used in conjunction with, again, I don't have a problem with it. I can see the thought process behind it, but it can't be the only thing that is there. It does say in the statute that, must be by a qualified, I think, company to do that, or there might be a memo that I have seen that came down from AOC in regards to that. But at any rate, how do you quantify or define that company, that qualified company? It's nowhere in
Yeah.
statute.
Well, we're always looking who to blame. So,
Right?
okay, so we're passing the buck. We require them to have a monitor, an ankle monitor.
Sure.
Well, but they took it off on the weekend and we don't monitor them on the weekends. Or,
Right.
on Friday at 5:45 they cut it off and so they got a 3-day head start of running.
That's
Well,
right.
it's not our fault. We ordered the ankle monitor. Well, okay, so whose fault is it? If we have a secure bond, we know whose fault it is or who's responsible for returning them, or they will suffer the consequences. It seems I don't. It seems like we're in a position where it's we're making arguments and passing the buck when we know what
Right.
works. I mean, we
We
know
do.
the different failure to appear rates with all these different release mechanisms, and there's only one that, and it's us that has anything uh, that's a good or a high or a low, I guess low failure to appear rate. Everything else has a real high failure to appear rate and causes backlogs or backlogs that get worse. So, I mean, we talked about the violent offenses, but I mean, what do you think's the big change, or what was the big change for the violent offenses under Irena's law? Um,
I do think that it's several things. I think that the IVC related to the violent crimes, and I think the violent crimes being spelled out, you must see a judge. You should have probably already have had to do that, prior to this, in my opinion. I know a lot of magistrates who will not set a bond on something of that nature and will say, hey, you're going to see a judge for this.
I
So
like that. I like it when a magistrate says, "You're going to go see the district judge."
yep, exactly. So to
Well,
me, I don't,
I saw that we also required magistrates to review the criminal history, and the way y'all do it different than Texas is you require the sheriff's office or the DA to provide the criminal history to the judge. And that's, I thought, was very smart because we've set up this whole statewide database. Y'all save millions of dollars doing it that way. The sheriff already has access to that. Just make him bring a copy with him.
so I will say in North Carolina here, I do think that's going to be a little bit problematic. Okay.
Of
Just a
course.
little
I
bit.
liked it, so it's going to be a problem.
It's just going to be a little bit problematic. I have asked a district court judge very recently, hey, do you see the history already, of who's being brought before you? The answer to that was most of the time, yes. And
Hmm.
it's provided to her by the district attorney. I have heard from other bail agents that that does not happen in their county, which is incredibly frustrating because, again, that magistrate's the one that took the officer's testimony, dealt with the defendant when they were brought in. I do think that their recommendation is great because they're the ones who were there
Hmm.
one on one, not, a few hours later, the next morning in front of the district judge. So if some counties, I believe, were doing it and some were not. If Iryna's law is going to force them to see that history, then amen and hallelujah.
Absolutely. I mean, I think that's the most important thing for setting bail is what's their criminal history.
Right,
The
right,
best predictor of what they're going to do in the future is what they've done in the past.
Right. I do think that looking at their history of failure to appear, looking at
Mhm.
their history of convictions, all of that comes into play, when you're trying to determine whether someone's going to come back or what their bond amount should
But
be.
does North Carolina do a good job of tracking failures to appear?
No, North Carolina is horrible about
Mhm.
tracking much of anything. Now, what I do have great hopes for is because this new e-court system is now live in all
Mhm.
100 counties as of October 13th, is that data hopefully should be able to be captured better. Okay, what's the
Sure.
failure to appear rate in Henderson County? On unsecured, on written promises prior to them being eliminated, on secured. What is the data? If you've got the system to do that with Tyler Tech and e-courts, then we should be able to capture
Mhm.
that data now.
Okay, with hopefully because I mean, we went in and data mined 2 years worth of data from the Harris County District Clerk's website, and they'd spent a long time setting up this system, which they were ordered in a consent decree to track failures to appear. And so we
Right.
followed their system. And after we pointed out that their simple release cases had an 83% failure to appear rate, on average for 2 years, suddenly they're like, oh, well, this website's a piece of crap. Well, you can't rely upon that data. I'm like, wait a minute. You mean your website that you spent all this money setting up is a piece of crap? Yeah. Uh-huh. Because we showed what it is. And they did the same thing in Illinois where the county clerk came out and said that the simple release people have a 75% failure to appear rate. And their response is, oh, that just can't be right. Yeah,
Correct.
you look at those numbers and you say that can't be right. If it is, we got a problem. We have a problem on simple release.
I do want to say one other little funny thing, which is off topic but pertinent to the conversation, is in that defendant does not
Wait,
go
wait,
back
start
to
over.
court.
Start over because you glitched a little bit.
Oh, I'm so sorry. It's pertinent to the conversation about bail in North Carolina. So if the defendants not go back to court, we have a certain amount of time in order to produce them back to the court or to
Mhm.
have the bond handled in some way, or bondsman must pay the county. That money, those dollars go to the school system in the state of North Carolina.
I've heard this before.
Yes. So when we file a motion, a school board attorney has skin in the game and can object to our motion. They're the ones actually who would object and not so much the district attorney. So we save tax dollars over and over again. And so now we have school board attorneys who are literally looking at why are they setting so many unsecured bonds? Well, sir,
Oh,
you're
that's a good
probably
ally there to have school boards come and say, why are you doing this? You're hurting us.
right.
Great point. Ooh,
So
I like that.
again, I know that's a little off topic, but definitely something
No, it's a
we
great issue. Great point. So let's talk about the next part we've already mentioned of Irena's law, talking about mental health evaluation. So one
right.
of the changes was one of the duties of the police processing is to inform the judicial officer if they think that there's something going on. And also, I think if we're just kind of generally talking about, they've added elements and giving the courts authority to order and require mental health evaluations in specific situations. And my response to that, that's all well and good, but are they going to have the capacity to do that when they order it?
So that's twofold. So I did double check with the magistrates on duty this morning to make sure that I understood it right.
Hmm.
And I did. I had it right. IVCs, involuntary commitments in the state of North Carolina. If there was already someone who was arrested and in jail, then the magistrate could not process an involuntary commitment. They had to
Ah,
have
hmm.
like a petition or something from someone else to
Sure.
start that process. They couldn't do it themselves, even if an officer came to them and said, hey, I think that we have an issue here. What they could do is take extra steps, contact the district attorney's office, see if they could get in front of a judge to have something done with the bond first, so then that the IVC could be processed. Now, this provision with the IVCs, I think, will change that. They will be able to process IVCs even if they are incarcerated, which is great because
Yes.
magistrates do need that ability at times for certain.
I think
Um,
that's great. But the problem is, we had a situation in Bear County where a person was arrested on a misdemeanor, $300 bond.
right,
And as soon as she went to the jail, she went to the infirmary.
Right.
And from the infirmary, she refused to talk to an attorney, refused to talk to the judge, refused to go to a hearing. She ended up dying in the infirmary.
Oh
And there
no.
was all this uproar about why was she in jail for months on a $300 bond? Well, because she had mental problems and she refused any help,
Right.
anything, and she died.
I do think that it's going to put a burden on law enforcement
Hmm.
because now it looks as if, hey, you bring one in and there are issues and they're addressed or they're identified, then that officer must take and or facilitate the transportation to a hospital or a qualified care center that can do these mental evaluations. Okay. And they can't leave that person until they're either taken in or discharged, is the way I'm reading that.
Wow.
So when it looks like, yes, there's going to be an undue burden or extra burden, if you will, maybe not undue on law enforcement, yes, I do believe that there will be. I don't know how some of the smaller counties that don't have a ton of
Yeah.
officers are going to be able to do that.
Well,
Um,
in Texas, you could only order a 72-hour commitment, and they're not eligible for that unless they're a potential risk of harming themselves or someone else. So,
right,
in Texas, I don't even think you would have the ability to commit somebody for 72 hours
right,
if they're just have mental issues.
right. It's
Uh,
I'm sure you've seen it in Texas and other states. While laws often have good intentions, sometimes the way that they're written have repercussions that maybe haven't been thought all the way through.
sure. Yeah.
Or if it works in this county, is it going to work in the
Or is it
99?
going to have unintended consequences?
Correct.
We've
Correct.
we've had that. We've dealt heavily with that. I mean, I've even got calls from judges about, so we did, this whole you have to be before a magistrate, you have to have review the criminal histories. Well, what about a judge who sets a warrant and sets a bond amount, but they haven't reviewed the criminal history? Is that now a
Correct.
permissible amount, or is it just a suggested amount? Is it a mandatory amount? And so we had this
Right.
unintended consequence for years, and we're, almost still dealing with it where well, that one is mandatory. That one's persuasive, so you have to go before the magistrate and uh, from this other county, and then it just becomes a big crazy. I mean, we have seminars on it.
Right. I will say the Pretrial Integrity Act was a bipartisan bill, again, due to Charlotte a couple of years ago, stating again that if you're out on some type of pretrial release and you do offend with a new offense, then you're supposed to be taken before a judge to have your bond set. The magistrate cannot set it.
Oh, we're moving towards that. We've done a
Mhm.
lot of statutory provisions on that, and so for our Chapter 54 magistrates, they can no longer magistrate certain offenses, and they're all violent, really bad offenses. But other parts of the Irena's law that we've talked about or we haven't talked about yet, the, uh, one is the Chief Justice now has the ability to remove or suspend magistrates. How is that being reported? Because I know that we already have a group that could do it. We've added the Chief Justice to the list of who can suspend a magistrate. But how was that played before the legislature?
I did not hear any discussion of that portion of
Uh-huh.
it at all. Not
Wow.
in the Senate committee hearing, not with legislators in the hallways, not specifically.
Well, and I
Um,
was talking last night and someone was asking me about that provision, and I'm like, even with that provision now in place, if that magistrate did the exact same thing she did in this case, I'm not sure that would be a grounds that would enable her to be suspended because of all the things you've already mentioned.
so the biggest thing is the magistrate is following a bail policy that is set
Hmm.
by the district court judge and resident superior court judge of that county/district. That is by statute. So if that magistrate is following what that bail policy says, then how can they be held liable for doing what they were told by their immediate bosses, if you will?
How do you
So
like that statute where it's a statute requiring the district judge or the district judges to set a bail policy that's then being followed by the magistrates? Do you like it? Good or bad?
I do not like it. If it was common sense, if it made sense, if it wasn't so soft on crime,
Yeah.
I would love it. But from one district to the next, that bail policy may in fact be different. Administrative Office of the Court obviously has a hand in that. Again, we've already talked about how those soft on bail policies
Yeah.
came down through the judicial side. So our
Yeah.
prior bail policy literally said you need to let them out on a written promise to appear or an unsecured bond or a custody release, setting a secured bond or even the house arrest. That was a last case
Sure.
scenario per the bail
Yeah. Well,
policy.
especially under the current politics, because
Mhm.
with the Soros groups, if you set a law and order policy, you're going to be attacked, and you're
Right.
going to have somebody running against you. So whether you do realize it or not, you're going to be softer than you would be even if you were law and order because you don't want to be attacked. You've mentioned that Iryna's law touched on the death penalty cases, and
It
I was
does.
trying to understand that because it seems like they were trying. I think from listening to what you were saying, what they were trying to do is say we've got so many cases on appeal and it's mucking up the system, so those all need to be resolved by a specific time. Is that
I
what it is?
think they're trying to fast track it, but they've also opened it up to where that all of those do not have to be heard on appeals in Wake County. Okay.
Ah, in one specific county.
Right, where the state capital is. Those can now be heard in the county of the conviction. So,
Spread out the cases, they could be heard quicker.
correct. Now, I think that some felt that that was not appropriate. They felt like, oh, if it was a Henderson County charge and this is gone, they're appealing it, and now it's going back to Henderson County. Some folks, on the defendant side might not want that. They want it removed from the area and where the case was, the conviction happened. They might feel like they have a better chance of that defendant, coming off of that in Wake County.
So
So,
Irena's law passed 28-8 in the Senate, North Carolina Senate, and then it passed 81-31 in the House, and then it was signed by the governor on October 3rd. So I mean, this month it was signed by the governor. And I mean, what do you think was the most controversial part of the proposed statute? Why
you
would it get
know,
31 votes against it?
I honestly think from sitting in that Senate committee hearing that morning, the biggest portion of the banter back and forth was about the death penalty, perhaps
Uh,
changes. Bail wasn't mentioned a whole lot. Mental health was definitely
mhm.
mentioned and discussed. Um, ACLU spoke about some things, but truthfully, it was the afterwards, especially the death penalty, I think has made a bigger splash than bail.
Wow.
Um,
So
the lobbyists,
locally, but nationally, I think the bail part has been played up in the press.
right? They're claiming that we've gotten rid of cashless bail, but you and I both know from this conversation, cashless bail is still alive and well in North Carolina,
Wow. Okay, so we talked about this is kind of something that can be built on going forward.
right?
But it's been portrayed as being received very positively by the public.
Right.
Do you agree with that in North Carolina that the
I
public has
do.
really supported this? So,
I
what
do.
would you like to build on going forward?
I mean, honestly, if I had a wish list, it would be let's reverse, give you back your written promise, put that back on the list, but get rid of the unsecured. Now, if you want to just get rid of unsecured and take that off the table, then I'll take it. You
Or
know,
even get rid of the unsecured for certain offenses?
I'm pretty confident I want to have gone completely.
Well, yeah, yeah. But if you can't get that, I mean, if you can
Right,
start limiting it, it's easier to grow that list out, I think.
right, right. I
But
will
yeah,
say
don't
that,
you and I can both go with a straight face and with a lot of
sure,
arguments that if
right,
you get rid of unsecured bail, it will improve your criminal justice system.
it
But
will.
the backlash from the left and the identity politics arguments that would be made against you because you're going to be racist, I'm going to be racist, I'm going to be sexist, you can't be because you're a woman. But
Right.
it
Well, I'm sure I can at some point. Somebody's going to say something.
you don't have a daughter, so no, you can't be. No. Um, okay, so the things we can build on is that. Are there anything else we can build on?
I mean, there's a ton of things that need to be solved in North
Sure.
Carolina, and whether that comes on the heels of this or, we try to fix some things and some other bills that might be on the table in short session, we do have a long road ahead of us, to be honest with
Who's
you.
your biggest allies at the legislature? When we learned a long time ago, when the argument comes from one of our friends, it's
Mhm.
received a lot better than when it comes from us. And so we've
Right,
started making our arguments through our friends a lot of times. And then I get
right.
put up as the pinata to get beat around.
It's a case by case basis. So
Mhm.
sometimes the district attorneys might be our friend. Sometimes the school board attorneys might be our friend.
Oh, I
Sometimes,
think your school board attorneys are going to be your friends a lot of times, especially on this list of limiting or getting rid of unsecured bail. I think they're a great source for that argument to come from.
well, legislatively, yes. In normal day to day operation, no, because they're the ones in front of the judge trying to
Absolutely.
take
Yeah.
our
Yeah.
money and we're trying to fight to keep it. But beyond that, Sheriff's Association, there
Yeah.
are a few sheriffs that I hope and pray will, see that we have common ground and we can work together. We've been working very hard to develop those relationships with all of those entities, and it will depend on what it's about
Hmm.
as to who is our ally. But those are generally the ones that we have. Sheriffs, well, we hope to have Sheriff's Association, district attorneys,
Yeah.
school board attorneys, AOC. We'll sit down and work with whomever we can to make it right.
We've had situations in the past where, the DA's association is not going to take a position and that we can't get an ally from them because of the large counties versus the small counties. And
Right,
the large counties have been kind of inundated with some of the soft on crime policies. And then the small counties are going to be law and order counties. So because of that
right,
dynamic, there's a lot of situations where they can't take a position on a bill. But the best compliment that I received in the last two legislative sessions where I've testified on something and I've used our data, and then the next one is someone from the Sheriff's Association saying, well, I was going to say the exact same thing he was going to say. So I'm going to say amen to Mr. Good. And I'm like, we've had so many years where they'll say behind the scenes we'll support you, but we'll never support you in front of the legislature. We've made a big move, and so that's the biggest compliment we can receive is
it
when
is.
they're citing our data as well.
Right. And you're completely correct. I hope to be where you are in just a year or two. I mean,
Oh,
I
look,
truly,
you're already there. Everybody in North Carolina already knows you. What are you talking about? I mean, look, by the time a couple of years comes around, I'll be having white hair, not gray hair. I mean, I've got natural highlights now. It's ridiculous. It's just getting old.
I shouldn't have worded that way. You'll use that forever now, right? That was too broad of a statement. Yeah, I don't have much of a professional, presence online, but it's just because people know me.
Yes, I am going to kid you about that forever, but
Yeah,
next time we see each other. Well, I mean,
hopefully soon.
yes, hopefully soon. I mean, look, this has been a terrible, terrible situation, a tragedy that like none I've ever seen, and I hope I never suffer something like this or see something like this. I remember my dad came up to a railroad track, and the car on the other side of the train, because they were both stopped, somehow became on fire. And so after the train passed, he ran over to the car and pulled out the guy that was on fire. And it scarred him for the rest of his life. I mean, was still talking about that for 20 years later, that he would never forget having to do that. This is that kind of situation. When you see this video, you will never, ever forget it. And so it's completely understandable why the legislator looked at that and said, we've got to address this. But I
Correct.
like what you said is this is a good starting point and we can build from that. And
Right.
I wish you the best of luck at building from this and having the school board coming in and saying, we need to take unsecured bond off this list next session.
That's right. That's right.
All right. Well, thank you so much for talking with us. We've gone way over time, but
I'm
thank
so
you.
sorry.
Yeah, it's all your fault. It always is. It's never my fault because I'm so short-winded. I just so short sentences. But it's very nice meeting you. I've enjoyed it a much, and I've enjoyed the discussion. I've hated what we've talked about, but it's been very educational. Thank you.
Yes, sir. Thank you.
Thank you for listening and come back for the next episode of The Bell Post.